an interpretation of the rule, both on its own terms and as understood by the government in its notification. This was meant to operate as a time-to-time benefit which had to be given, because the very purpose of dearness allowance is to protect the real value of money. Well, if one understands this aspect, that dearness allowance is really to protect the true purchasing power which your wages or your salaries are meant to achieve, and keeping in mind the revisions which take place, well, there is an adjustment, and that, well, is not something which is a matter of bounty, nor is it, my lord, a matter of, if I may say so, a claimable right per se. But if, my lord, the rules give this as a part of your emoluments, based upon an acceptance of the recommendations of the Pay Commission, then, my lord, I submit, that becomes a compellable obligation. So, my lord, the right to get existing emoluments reckoned in accordance with the rules is a legal right vested in me by the rules, and imposes, my lord, what we call in jurisprudence a corresponding obligation or a duty on the state to abide by that rule. And, my lord, that rule, therefore, can legitimately be the subject of a mandamus. Because, my lord, a mandamus always is in the context of a public duty, or, my lord, a statutory duty, or a constitutional duty. Here it is a case of a statutory duty which is enjoined by the rule. Now, my lord, may I straight away take your lordships to the first division bench judgment, and only 2 or 3 paras to satisfy you that that judgment, my lord, analyzed these defenses. This very same judgment of 1954 Supreme Court, which was cited by Mr. Divan yesterday, that is, my lord, the state of Madhya Pradesh judgment, was also examined, and the court distinguished it on the ground that the words of Fundamental Rule 44, which was being interpreted by Justice Venkatramaya in that judgment, provided for the word may. And because there was the word may, this was a discretion which was vested in the government. So, my lord, this is one aspect. The court also dealt with other judgments and said that the law is, if there is a pay commission, it is not binding on the state government. The state government may accept it, may not accept it, may accept it in part, may accept it in total. Now, my lord, the court, however, says that if it is accepted and is translated into a rule, then that rule imposes an obligation. So then the rule, well, a rule could also permit discretion. Now the question is, my learned friends in their interpretation want to invest this rule with having induced a point A, after which, my lord, there is only a remnant of discretion. And that construction, my lord, is the one which I seek to displace in my submission for your lordship's kind consideration. Because this is, my lord, really the scope of contest. Now, my lord, I will also place those paras of the administrative tribunal. My lord, they were placed, they were rendered, my lord, in a context. The context was that, my lord, the central government was making it a practice to give dearness allowance when necessary, twice a year, because, my lord, twice a year you have the benefit of the discovery of the index. This word average, which your lordships find, is really, my lord, an average of 12 months, which is actually the basis of arriving at that figure 536 in the year 2005. So that is why you have the word average index, because it's over a period, weighted average, my lord, for 12 months. Now, having said that, my lord, let me take you straight away first to the rule, and also explain, my lord, that it is time to time, because that is the purpose of the rule. So may I straight away do that, so that we deal with the heart of the matter.
We want to request.
Please, certainly, my lord.
We are conscious of this fact that we were conscious that you're going to argue that the division bench has already settled the issue and they have not filed any appeal, so therefore a judicata would apply. You are aware of that. Now, we would request you for one thing, because it is going to have pan India implications. You please proceed as though we are hearing it for the first time.
Certainly.
Because we have to lay down.
Certainly, Malord. Certainly. There's no difficulty at all.
That's how we will.
No difficulty at all.
Mr. Diwan,
Yes.
Sibyl,
Yes.
They were focusing only on the rule.
Yes.
So therefore, how do we read the rule
Yes.
to your benefit and advantage is what we want you to address.
Certainly, Malord.
First, and then we'll
Yes, certainly. Certainly.
the manner in which.
Certainly. And Malord, even if it is pan-India, I'm not, if I may say so with respect, I'm not overwhelmed by it, because even consistent with all the judgments which I'll place, Malord, it is very clear that the law is that dearness allowance is an integral part of remuneration. Secondly, it is vital because the real value of money must be available to an employee of the government. The third is, if it is left to the determination of a pay commission and the pay commission makes a recommendation, it is open to the respective state government to either accept it or reject it. It is not binding, proprio vigore, although there are judgments which say it is entitled to some weight because it is an expert body, but we will leave it at that. But if it is accepted, then it binds the state government, and if it is, Malord, then metamorphosed into a rule under Article 309, then the rule, Malord, becomes a compelling obligation. So this, Malord, is the. Now, Malord, may I straight away take your lordships to the rules, please? And before that, Malord, if I may invite your lordship's kind attention just to see the context of the rules, which is, Malord, please see Annexure P1, which is at page 97. It is a part of the Pay Commission's report produced by the state. That would be printed page 97, Malord.
Chapter 10.
Yes, chapter 10. And PDF would be 137. This chapter 10, my Lord Justice Mishra has that. In this chapter, we have discussed 4 of the most important allowances now available to the state government employees and also to some of the non-government employees covered by our terms of reference, namely dearness allowance, medical allowance, house rent allowance, and non-practicing allowance. We have not been able to devote our attention to other allowances, including the so-called special allowances that the state government currently pays to its employees, some of its employees. We propose to deal with these allowances in any of the later volumes of our report. Then, Malord, 10.2. Now we first deal with dearness allowance. Due to the unabated pressure of inflation in the economy, the real value of salary fixed periodically by pay commission gets continuously eroded with the passage of time. Thus arises the need for payment of dearness allowance so as to protect this loss. Now, Malord, this is a rationale for dearness allowance. This is not, Malord, disputed by the state. The state does not say that there is no inflation. The state does not suggest that there is no increase in the cost of living. Now, Malord, please come to 10.3. The state government, since the 1st of April 1979, has been following the same principles followed by the Government of India in the matter of calculation of the quantum of each installment of dearness allowance. But almost invariably, there is a time lag in actual payment, and when the same is paid, the same does not include any areas. Right now, only one such installment has remained, due which the Government of India sanctioned on 1st of July 2008. The last installment, which the state government has sanctioned with effect from 1st March 2009, was sanctioned by Government of India with effect from 1/1/2008. A major grievance of most of the associations of employees has been non-payment of the DA installments in time as per Government of India's policy. This is payable twice a year with effect from 1st of January and 1st of July each year. They are also agreed because of non-payment of arrears. As per information available, we find that apart from notionally allowing the pending installments at the time of the pay revision in the years 86 and 98, the actual payment of DA during the years 97 to 2008 has been as under. Then, my lord, 10.6. It is evident from the above that state government sanction of the installments does not follow any definite pattern. It is clear that there are delays in payment of various installments of DA, and there cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that with some extra effort, the state government should be in a position to clear the backlog of the loan installment, which was sanctioned by the government with effect from 1st July 2008, and then, these are the critical words, my lord, fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. If it is done, it will mitigate a long-standing grievance of almost all employees within our terms. Now, my lord, before I show you the rules, there is a notification which explains, my lord, how this pay commission came to be constituted, how it has submitted the report, and how has the government viewed it, and how the rules have been framed. May I show that straight away, my lord? Your lordships will find this is annexure. This is, my lord, annexure P3. Well, there are 2 memoranda. One of them is numbered as 1691F, and the second one is 1692F. But let's take, my lord, the first one, which is 1691F. That your lordships will find is at printed page 155. That is, my lord, if I may say so, it's the scanned copy. May I take you, my lord, to the better version, the typed version, which is at printed page 162.
Yes.
Subject clarificatory memorandum on the West Bengal Services Revision of Pay and Allowance Rules 2009 and on allied matters dealt with by the 5th Pay Commission. In Finance Department resolution dated 28 August 2008, the government constituted a pay commission to examine the present structure of pay and conditions of service after taking into account the total package of benefits available to the following categories of employees and to suggest changes which may be desirable and feasible, keeping in view the decisions of the central government on the recommendations of the 6th Central Pay Commission. And now, my lord, after this, your lordships will find over the page 163, just above para 2, the Commission submitted its report on the 12th of February 2009. After due consideration of the recommendations of the Commission, the Governor has been pleased to make the decisions set out in the following paragraphs in respect to the employee under category 1A above. Scales of pay. The government has accepted the recommendation of the Commission in respect of running pay bands and grade pay corresponding to each scale of pay without any modification. Now, the next para is important. The revised pay structure, which has been prescribed by the government, is set out in Schedule 1 to the ROPA Rules 2009 relating to services generally published with the notification 1690F. Then, the various rules and regulations. And then these have been, published in the Gazette. Now, here, your lordships will find Please now just scroll over to the most important part, my lord, which is at printed page 166. 166.
Clause 10.
Clause 10. And the most critical part, my lord, of clause 10 is this. Consequent upon revision of... Sorry.
Yes.
This is 166. Consequent upon revision of pay of government employees in accordance with the West Bengal Services Revision of Pay and Allowance Rules 2009, the dearness allowance which a government employee is entitled from time to time since the first day of January 2006, because that is the date of the Central Pay Commission, 1/1/2006, needs to be related to pay in the revised pay structure. Now, my lord, your lordships may kindly see the crucial words are the dearness allowance to which a government employee is entitled from time to time. Since the 1st of January needs to be related to the pay in the revised structure. This is, my lord, in response to my Lord Justice Mishra's question that how do the three clauses work? Because the word is aggregate first. It is 1 plus 2, on which, my lord, there is 3. Then please see, now this is, my lord, quite important. And this is how, my lord, the rule needs to be looked at. Now we come to the rules. Now please see now, my lord, the rules.
Sorry, 1 minute.
Yes.
The government notification of 23rd of February is the what page?
Yes. That is, my lord, that is the next annexure, my lord, which is 1692F. I'll place that too at this juncture. And this, my lord, actually, if I may say so, completely buttresses the position of the respondents. Please see, consequent upon the revision of pay scales of government employees, my lord, that is printed page would be 168. I think there is also a typed copy which has been provided, which is at printed page 170. 170, it's easier on the eyes. The governor is pleased to decide that the whole-time state government employees...
That's something else. That's something.
Oh, sorry.
You have to read from.
Oh, I have to read from that, yes. Yes. I'm grateful. Well, Lord, please therefore come back to 168. Consequent upon the revision of pay scales of government employees under the provisions of the West Bengal Services Revision of Pay and Allowance Rules 2009, it has become necessary to relate, my lord, this expression, to relate dearness allowance admissible to a government employee to his basic pay in the revised pay structure in the case he has elected or is deemed to have elected to draw pay in the revised pay structure prescribed under the aforesaid rules. As has been laid down in Rule 12 of the West Bengal Services Revision of Pay and Allowances Rules 2009, that no areas of pay and allowances to which any government employee may be entitled in respect of the period from 1st of January to 2006 to 31st March 2008 shall be paid to the government employee. The dearness allowance admissible to a government employee needs to be related to his pay in the revised pay structure with effect from 1st of April 2008 only. So, my lord, while the revised pay structure would be worked out with effect from 1st of January 2006, but you will get no arrears. And from 1st of April 2008, that is, my lord, the newly revised pay, you will be entitled to dearness allowance. Accordingly, the governor is pleased to decide that the dearness allowance payable to a government employee with effect from 1st of April 2008 shall be at the following rates. And your lordships will find this 2%, 6%, 9%, 12%, 16% are the percentages given by the central government, although it was with effect from 1/1 2006. So, my lord, what is important is that time to time. That is reflected in this very notification itself. 1/4/2009 onwards, it says 16% and it leaves it at that. Now, my lord, let us go to the rule, because this really is the subject of interpretation in our case. Please come to the rules. The rules are, my lord, they begin annexure P2 at printed page 100. And if your lordship sees,
Yes.
in the foreword, which is at printed page 101, it says the West Bengal Services Revision of Pay Allowances Rules 2009. Sorry. That is, my lord, forward. But it's important to show,
Better-
page, my lord, there's
Better if you read 125.
yes,
That is the
One page.
legible one. Yes.
I'm grateful, my lord.
Yes.
I'm very grateful, my lord. The West Bengal Services Revision of Pay and Allowance Rules 2009 and other notifications on revision of pay of police personnel, civil defense personnel, staff and officers of the Public Service Commission, West Bengal, as well as a memorandum on the West Bengal Services Revision of Pay and Allowance Rules 2009 and allied matters have been published in the extraordinary issue of Kolkata Gazette dated 23rd February 2009. Government has also issued orders sanctioning fresh installments of dearness allowance with effect from the 1st of April 2008. My lord, it should be not 2009. That I think is an error. It's April 2008. So, my lord, now we come to the rules. Let us see the rules.
There is no error because the original one says 2009 only. We really don't know why.
Yes, my lord, but the rule is from 1st of April, as your lordships have seen, 2008. Now, please come to, my lord, printed page 126. Please see 1-2. They shall be deemed to have come into force on the first day of January 2006. That, my lord, coincides with the central government, the sixth pay commission of the central government. Then please now, my lord, come to rule 3. In these rules, unless the context otherwise requires. Now, my lord, nobody has pleaded that there is a context which otherwise requires to depart from these definitions. Please keep that in mind. Now, my lord, the first is existing basic pay. Existing basic pay means the pay drawn in the prescribed existing scale of pay, including stagnation increments, if any, but does not include any other type of pay. And then, my lord, we have that expression existing scale. Then we come to existing emoluments. Existing emoluments mean the aggregate of, which is, my lord, it's the total which has to reach an employee. But it has different elements. The first is existing basic pay, that is, my lord, the unrevised pay, dearness pay appropriate to the basic pay, and dearness allowance appropriate to the basic pay plus dearness pay at index average 536, 1982 is equal to 100. Now, my lord, the use of this word index, my lord, index itself, my lord, it's a Latin expression, it means a pointer. This index is really the pointer. And how do you calculate the dearness allowance? It is with reference to this numerical 536, 1982 is equal to 100. That is, my lord, 100 rupees of 1982 today is unique 536 to draw the value of 100 rupees which you had in 1982. Now, my lord, your lordships will notice, and that there is actually, my lord, a calculation which I made. It is clear, my lord, from all the rates declared by the central government. They have used this formula, and this formula is the other side as well. This formula, Manoj, shows that the denominator is always 536. So that figure 536, which your lordship saw, is critical. Please have a look at this. Please see, Malad, please see for a moment column H. We are now talking of April 2008. In April 2008, Malad, the DA given by the central government was 12%. Does your lordship find that in column C? Yes.
Yeah.
I'm sorry.
Yes.
It was 12% in April 2008. Malad, we got 2%. Then, Malad, the balance was 10%. Now, Malad, what is the formula for calculation of central government DA rate as reflected in column C? It is 605. That is, Malad, 536 had gone up to 605.
Yes. Yes.
This 536, Malad, the AI CPI index rose to 605. So, Malad, you divide it by 536 and you also deduct that 100 because 1982 is equal to 100 has already been subsumed. That is how you get, Malad, 12.87. But, Malad, they now forget the decimals. They give it closer to, that is how, Malad, it is done. So each of these, your lordships will find, January 2009, 22%, and Malad, we got 9%, but the calculation in H is 656. Sorry,
No, it's all right.
656 upon 536, keeping in view 100, that comes to 22.39. So that figure, that average index, which says 536 within brackets 1982 is equal to 100, is Malad, the factor of calculation at each point of time when the index changes. Now, please see the next one, 727 divided by 536, and again offsetting 100, you get the percentage 35%. 815, again, Malad, you get 52%. Then 887, you get 65%. So, Malad, there is actually a scientific, it is almost like an actuarial calculation. Please then turn over the page. In January 2013, the figure, Malad, becomes 969. That takes you up to 80.78%. Then, Malad, in January 2014, it increases up to 1075, so 100.56%. Then January of 2015, it goes up to 1143. That is how it comes to 113%. In January of 2016, it goes to 1210. And so on, Malad. Your lordships will find the calculations are available right for all the revisions done by the central government using the AI CPI index. So, Malad, this average is done only by the central government. Now, if you look at the structure of the rule with me now, Malad, the words are important. Dearness allowance, the crucial word, Malad, here is appropriate. That word appropriate means it must be appropriate to the basic pay plus dearness pay at index average 536. So, Malad, this index average 536, if 536, Malad, undergoes a change, then taking into account 536 as a denominator, you work out the percentage of increase. This, Malad, is really the purpose of this particular rule. So, Malad, instead of even taking a position that this is an implicit arrangement in the rule, my submission, Malad, is that this is explicit because it is A, an aggregate, B, it is appropriate to the revised pay, C, at index average. And that index average, Malad, once you say index, it means, Malad, that that average will move according to a change in 536. And that is why, my lord, that para 10, which I showed to your lordship, said time to time. So this, my lord, is really the reading of the judgment of the division bench of the High Court. But, my lord, there was one other question which arose before the division bench. There were employees, my lord, of the government of West Bengal who were governed by the ROPA rules. But fortuitously, some of them, my lord, were working at the Bonga Bhavan in Delhi. Some of them were in a youth hostel in Chennai. And, my lord, they were being granted actually the dearness allowance exactly on the basis of the central government rates. Now, that was an additional factor for the court to say that this is a case of discrimination because they're governed by the same rules. And there is no difference, there is no intelligible differentia that they should get a higher. But it was taken into account. But it was not the primary reason for applying. The primary reason is that in the very nature of a dearness allowance, if it is meant to offset, my lord, cost of living increase, the increase, my lord, in essential commodities, my lord, it is done also in a very scientific way by the Bureau of the Labour Ministry. They, my lord, actually get data from the Ministry of Consumer Affairs every month on every item. And, my lord, why they apply industrial workers is they take, my lord, much lesser in terms of that is essentials, basic essentials which are required. But if their prices have gone up, then, my lord, they take data from all over India and make an adjustment. And this adjustment, my lord, like even today, as we speak of yesterday, my lord, the central government for the festive season, but because the AI CPI index went up, gave, my lord, a 3% increase to the employees. Now, what I'm saying, my lord, is that this is on the basis of understanding that dearness allowance is not a matter of race. Dearness allowance is integral for the real value of a wage. So, my lord, if the real value of a wage has to be protected, of course, my lord, if the state of West Bengal, let us say, had a Mahalanobis formula, a different formula to actually calculate dearness allowance, it's very different. My Lord Justice Mishra asked an extremely critical question yesterday. What was the basis on which you checked? What was the working? The working, my lord, for a good part of time was only the central government's, but it was, my lord, postponed, as your lordships have seen. So, my lord, the issue is, if the rule gives this method of calculation, is it not binding on a state government in terms of the emoluments which have to be available to a government servant? In addition to this, my lord,
Can you provide us an exemplar of an employee working at Banga Bhavan in Delhi or at Chennai being paid DA in terms of the central government rate?
Yes, my lord, I have
An exemplar
yes,
of
yes,
any employee
yes, my lord, yes.
who is working
I'll-
at Banga Bhavan vis-a-vis the same cadre of employee getting a less amount of DA if he is working in Calcutta.
Exactly. My lord, I'm showing you the chart. I'm very, I'm deeply grateful. Please come, my lord, to a chart. Yes. Please see, my lord, Annexure CA2, which your lordships will find is at PDF page 895, but it might be printed page 17. It's a part of the counter affidavit of the second respondent. It is an annexure, my lord, CA2. And this has not been disputed. C1.
It's a counter affidavit.
Yes. Of respondent 2, my lord.
It's mine, my lord, and it's
Yes.
not been disputed.
Yes. The chart is extremely useful. I'm taking advantage of the material available for us.
Counter of respondent number 2.
Yes, my lord.
Page?
Printed page, my lord, this would be 17. Printed page 17. Annexure C1.
Yes, please.
Now, your lordships will notice that at page 17 is the chart. Chart showing the discrimination of payment of dearness allowance between the state government employees working at Bonga Bhavan, New Delhi, and Youth Hostel, Chennai, and West Bengal state government employees working in the state of West Bengal in connection with ROPA 2009 and 2019. Now, my lord, your lordship sees April 2008 is from when, my lord, we were entitled to a pay. 1st April 2008. We got 2%. Is your lordship able to see that chart? We got 2%. Your lordships recollect that in that notification. My lord, Bongo Bhavan, they applied the central government dearness allowance and gave 12. Similarly, my lord, all the payments which your lordships will see in column number 3 are exactly those of the central government AICPF. Well, this is not even one exemplar. This is continuing from 2008 all the way. Your lordships will find what was it which we got in the last but one column, and what is it, my lord, others who were also governed by the same statutory rules. What did they get? So, my lord, the suggestion by the state that they don't know how to calculate this is certainly not, my lord, because they are the ones who gave this. Please see 27. 35, they followed strictly, my lord, all the way, as your lordships will find, right up to, all the way, my lord, I'm now going to take you right up to 2019, December 2019. They got exactly what was available in terms of the calculation of that formula for the central government. So, this is the point, my lord. And this is not merely a case of incidental discrimination. This is a case where the same employer, for some of its employees, is making available dearness allowance exactly, my lord, ditto of the central government based on this formula. So, my lord, the point which is being made by Mr. Diwan, that it was static, it became fossilized on the day. Well, as I said, in any case, the pleadings, my lord, are in fact inconsistent with this. If your lordship see the judgment of Justice Samanto and Justice Tandon, the two learned judges, nowhere, my lord, is there a suggestion that it stood frozen at a point of time, because, my lord, dearness allowance in its very concept is a variable allowance. This is the point.
Is there any separate GO issued by the government of West Bengal in respect of the Banga Bhavan employees and
No.
Chennai employees?
No.
I think there is, my lords, I just
Has been subject to corrections. Page. Annexure. Annexure 31, my lord, I'm given to understand of the page 31. Please go to page
Of the same one,
31 of the counter
same counter of R2
of R2, my lord.
page.
It's page 31, my lord. Annexure C2. Well, this is actually with reference to the ROPA rules of 2019.
This is the second set.
but it continues same problem.
My lord, I want to make one thing clear. These cases are governed, my lord, with reference to the ROPA rules of 2000 and 2008-9. 2009 rules, my lord, are the issue in this case. But even after the ROPA rules of 2019 came, it's important to see, my lord, this very significant point.
No, this happened for the first time in 2019.
But that is because the 2019 rules, my lord, did away with dearness allowance in the rule. So what they did was, they issued this order consequent upon the revision of pay and allowances of state government employees, with effect from 1st of January 2020, under ROPA Rules 2019, Governor has been pleased to order that the state government employees posted in New Delhi will draw dearness allowance, house rent allowance, so and so, with effect from dearness allowance at the central government rate. So, my lord, although the new rules abolished dearness allowance, but they followed that same pattern of giving the central government DA in respect of these employees. And, my lord, the 2019 rules are not the subject here today because, my lord, still discussions are going on. The Pay Commission, which dealt with the 2019 rules, my lord, the report was published only 2 months ago. So that is being examined, how to deal with that. Because, my lord, that actually did away with dearness allowance. So notwithstanding dearness allowance disappearing from the 2019 rules, they continued to give, my lord, the central government DA.
Presently, they are not getting DA.
Where, my lord, they were no, now, my lord, now after a period, that is the new rules of 2019, my lord, they were notified in September 2019 with effect from 1/1/2020. With effect from 1/1/2020 for a period of almost 2.5 years, we didn't get any DA. Then, my lord, there has been small driblets of a minuscule percentage which has been given to us as a dearness allowance, which is why, my lord, it is important to state the point that, my lord, this is not gratis. This idea that dearness allowance is something which is gratuitous is
The methodology is the same.
method exactly.
2006 to 2008,
Yes,
nothing was paid.
exactly.
Again, 2019 to 21,
I'm grateful.
nothing was paid.
Exactly, my lord, this is the point.
They are saving it
Yes,
like old days money lenders.
and my lord, I
And the
couldn't.
businessmen
Yes.
use the money
Yes.
given to others
Yes.
for their own business.
My lord, for 2 years not to pay you from 1st of April 2008 and give you in driblets. That is, my lord, what was given in 1st of January 2006, you're making available to me in 2008. So, my lord, this is the real case.
Perhaps you can, and let us know.
Yes,
The counter affidavit filed by
responded to.
page 16 and page 31. These are documents of the year 2022
Yes.
and 2020. Is there any document available there on record, or perhaps you can place it? As
So,
to
may I just search the record and give you a
what transpired?
yes.
We are interested to know between the period 2009 and 2009.
Yes, 2009 up to 19.
That would be. You may not answer immediately. This
I just yes, certainly, my lord.
My lords, we do actually have it.
That was reflection.
we know that, but we just want to. Just look into it.
Yes, we'll do that. My lords, we have it.
If you don't have it on record, doesn't matter. You can still give it to us.
Certainly,
It's on
my lord, we'll
record.
just.
We know that. In 5 minutes, give us 5 minutes.
Certainly.